sophisticated party made a promise in which it expressly chose to make part of the letter of credit a reference to the arbitration clause, and is now trying to avoid fulfilling its obligations. Mr. Chairman, if the tribunal does not have any further questions regarding consent, suspension, or the ability of this tribunal to determine the validity of the Acceptance Act and the amount to be finally paid to the claimant, that closes my submissions.
Thank you. Just two very quick questions, and along the similar lines of the questions which I asked you to respond to. So how would you address the argument raised by the respondent that there's a danger of having inconsistent results between the two tribunals?
Yes.
One determination of the...
I would argue that there's no risk of inconsistent results here because, as I've stated, there's different legal standards that are applying. So for example, if you're looking at the validity of the Acceptance Act under the shipbuilding contract, you're going to be using the applicable law there, the CASG, and you'll make a determination in that proceeding. However, this tribunal will be looking at it under the lens of the ECP 600. So there's not a risk of inconsistent results.
But it's a pure factual determination whether the document is, whether the signature is valid and whether the document has been validly signed or not.
But there could be a different determination. My colleague will show that it's on its face standard, right? That the bank needs to do. So if the tribunal first buys the honesty standard.
And then the second question is with regard to incorporation of the arbitration clause. So, and how would you address then the argument raised by the respondent that it's, if I've understood correctly, and correct me if I'm wrong, it makes it's a nonsense to say that all the terms would have been incorporated into the letter of credit, because that would therefore make a burden on the bank to actually build the up.
Well, respectfully, Mr. Arbitrator, I would argue that it's common practice not to make these sort of references. But as I've shown, the bank specifically included the language full effect. The letter of credit is silent. It's clear through this language of full effect that they intended for it to apply. I mean,
only to the arbitration clause or all the clauses?
Well, for the whole, all of the clauses of the arbitration, all of the clauses of the shipbuilding contract to apply, including the arbitration clause. It states without prejudice, and there's nothing in the letter of credit to show that there's another imagination of a different form of dispute resolution. So, although it's not common practice to make these references, once the sophisticated bank decides that it's going to move forward and make such a reference and include the specific language, full effect, it must be held that it's promised that it's making and its incorporation of the reference.
Thank you.
Just one quick question.
Please.
With regard to the suspension, as we're informed in the second proceedings, the buyer of the yacht is planning to set off $18 million to the seller. So if we're considering the possibilities of suspension, possibly please address the issue whether we should take into account this fact that should the second proceedings be resolved in favor of the buyer, the respondent will not have to pay to the claimant in that case.
Well, I would answer that this tribunal cannot speculate as to the result of what the other proceeding might be. It could be that the seller wins in that proceeding and then therefore it needs to get paid under the letter of credit. So we can't speculate as to who will win in that proceeding. I don't think it's within the right of this tribunal to speculate.
This question is not with regard to the speculation. It is about the reasons for suspension, no suspension. So if we, for example, decide not to speculate and to suspend, by this we'll just avoid the risks of contradictory decisions.
Well, Ms. Arbitrator, I would answer your question that the ILA set a series of guidelines to address this exact situation. It says that you must apply the triple identity test, and I've shown that under the requirements of the triple identity test, the identity of the parties are not the same, the issues are not the same, and the cause of action are not the same. And you need to have all three of those. So primarily, that primary threshold is not met, and to determine otherwise based upon a speculation of how that other case could possibly proceed, which we don't know how it might end up, it would not be a strong grounds.
Thank you, Counsel.
Thank you. Any rebuttal?
Yes, I want to
Please.
state some facts. Okay, first of all, I want to state that I want to answer to the statement that there is no risk premise in the rest. Yes, the claimant stated that triple test is not met. But we already said that there is Article 6 of International Association of Organization of International Association, and there is a possibility that if there are three conditions that we already mentioned in our speech. If all three conditions are met, that about our arbitral tribunal, it's possible to request for the suspend of the arbitration if also even there are different parties and there are different subjects. That's first. The second, I want to say that the claimant said that the decision of the other case doesn't have some influence on our case. And for example, we are waiting for the final award. But we are aware that, for example, the case 1998 was initiated on 25th of March 2016. But the request for arbitration in our case was initiated on the 1st of May in 2016. So, due to the common sense, we understand then that the arbitration in the other case will be consulted previously and we may have the impact on our case. And then last argument that I want to state, it's that the claim states that there is no limitation in arbitration clause to the parties. But we understand that parties to the shipbuilding contract, either buyer and seller, there is no evidence that some kind of bank, some kind of other third party is party to the contract. Of course, there is no limitation, but we can't interpret the word parties as is very, very extended. We know that it is buyer and seller to the shipbuilding contract.
If I may,
Please.
the claimant states that the bank put Article 10 in the LC, but all the terms of the LC were told to the bank by the buyer. And we didn't have any intention to influence those terms, so we are not bound by the arbitration clause.
Thank you. You finished? Rebuttal from the claimant, please.
Great. I will raise 2 points here. The respondent is trying to force the realist defendant's test, and they're making the case that the buyer and the bank are sharing identity here in order to fulfill the requirements, and that the bank is standing in the shoes of the respondent. But the respondent can't have it both ways. The respondent can't allege that the parties are the same when it suits them for this pendants, but then argue that it doesn't apply to the arbitration clause. Secondly, I would like to direct this tribunal to the language of full effect. Again, a sophisticated bank would not include the language full effect. It did not intend for all the terms of the shipbuilding contract to apply. And the letter of credit is silent in terms of dispute resolution, and therefore the incorporation of that.
Thank you. You are finished. So I think we can proceed with the pleadings on the merits. I understand that you have agreed that the claimant, as it should be, has the floor.
Yes.
Proceed.
Members of the tribunal, my name is Laura Townsend, and I will be presenting the seller's arguments on the merits. The seller, our client, is entitled to payment. The tribunal should not uphold the respondent bank's rejection because the bank did not follow the procedure that it agrees it was bound to follow in making its determination. Letters of credit, including the one at issue in this dispute, are governed by the Uniform Customs and Practice for Documentary Credit. The most recent edition of this is the UCP 600, which both parties agree applies. One of the most important principles of the UCP is that letters of credit provide certainty of payment. To facilitate this, documents in a presentation are evaluated on their face for compliance. This idea is captured in UCP Article 14. Accordingly, banks do not look to or look for information outside of presentation to make their determination. The day S made its presentation, after reviewing the documents, the bank wrote that it was planning to honor and fulfill its obligation to pay within the next 3 days. That letter is Exhibit C9. It's on page 29 of the record. The bank then improperly solicited input from the buyer, who then wrote the bank ordering it not to pay. It was only after these two events in which the bank forwarded a copy of the presentation for the buyer's consideration that the bank changed its position and decided not to honor its obligation to pay. Now, it's clear that the formally communicated determination that the bank gave to the seller was a no. But that's not the end of the question. First, we know from UCP Article 5 that banks deal with documents and not performance. And from UCP Article 13, that once a bank has decided that a presentation complies, it must honor payment. The UCP does not require any notice of acceptance of a presentation to the beneficiary of the credit. Now, we have evidence where the bank says it has reviewed the seller's presentation and is planning to honor it. That's available in Exhibit C9 on page 29 of the record. Based on these facts and the principles of review under the UCP already discussed, this is enough for this tribunal to find that the bank had made a positive determination and decision on the presentation, and now it is bound to honor it. Second, the official determination given by the bank is not valid. The bank only changed its plan to honor after consulting with a third party regarding the presentation, and that party was the buyer. The buyer, who is the holder of the account from which the payment under the letter of credit will be drawn, demanded that the bank not pay. This external influence is not proper banking practice for letters of credit. If the core tenet of on-their-face review is violated, tribunals should not uphold that rejection. I'd now like to address the issue of the signature on the act of acceptance. The signature on the act of acceptance clearly looks different, but an allegation of fraud, as the bank has raised, is a serious one, and one which requires clear and obvious evidence that the bank has not presented, either at the time of its determination or to this tribunal. Now, neither side has evidence which unequivocally establishes who picked up a pen and signed the act of acceptance. But the act does have a company seal for the buyer's company, which clearly matches the one on the shipbuilding contract, was added to the act of acceptance after the signature had already been made, and whose authenticity is not contested. We have also provided this tribunal with additional evidence of the act's authenticity to help it in making its decision. If you would please turn to page 51 of the record, you'll find testimony and newspaper articles showing that Ivasov attended and participated in the acceptance ceremony. And beginning with Exhibit C14 on page 55, that Ivasov and his wife have accepted and begun using the yacht in question. Now, respondent's primary support for its position that the signature is not valid is a letter from Ivasov, a long-term client of the bank, who says that the signature is not his as a reason for his account to not be charged for the yacht he has begun using. Only after this letter does the bank, which previously found the act compliant, object to the signature. This kind of self-interested allegation, without clear and obvious evidence to support it, does not meet the high standard required for letter of credit transactions. With respect to the issue of the ship safety certificate, such a certificate was not required for payment. As my co-counsel has already argued, the letter of credit was issued by a sophisticated party, the bank, with full effect to the shipbuilding contract. The contract specified payment under the letter of credit would be made upon presentation of 5 documents, none of which was a ship safety certificate. Those documents represent the complete understanding of the parties regarding payment. That's captured in Article 19 of the shipbuilding contract on page 19. And the respondent has acknowledged in its procedural presentation, this shows that the letter of credit was not intended to limit the rights of the seller. In addition to recognizing that a requirement of a ship safety certificate is outside of the parties' understanding, this tribunal can and should give preference to the parties' intent as expressed and written within the shipbuilding contract over literal text. If the letter of credit, furthermore, does not specify the origins or content of a document which is required for payment, then banks can decide if a document or combination of documents within the presentation fulfills the function of the required document. Here, there was no information regarding the origins, acquisition, or content of the ship safety certificate. The seller did present the bank with a certificate of origin and a certificate of quality, which the bank, in its short review of the documents on their face, decided appeared to fulfill this function, such that they did not raise any objections. Additionally, the bank is precluded from maintaining this and the previous objections to the documents before this tribunal. If a bank decides to reject a presentation, under Article 16 of the UCP 600, it must provide notice of its decision, its reasons for that decision, and tell the seller what it is doing with the documents. As the bank did not provide notice of the status of the documents in its letter to the seller, which is available on page 31 of the record, it is precluded from maintaining that the presentation does not comply. Second, the seller is entitled to the remaining payment because it has fulfilled the requirements for payment under the shipbuilding contract. This is a case about a seller who has built, after an agreement, who has built a custom yacht, and there was an agreement for the buyer to pay for it. The buyer designated that that payment would be from the respondent bank. Not only has the seller built and delivered this yacht, but it has also presented the agreed documents for payment to the bank. Accordingly, this tribunal should award the remaining amount to the seller, along with the other requested relief for interest and costs. If there are any further questions, I'd be happy to address them at this time. If not, I will close my submission.
Thank you. I'd like to explore a little bit with you the element of fraud, or the concern that this is a fraudulent document. Now, I take on board what I understand what you're talking about with the UCP 600, but does the UCP 600 address circumstances of fraud?
It does not.
In which case, what should the bank have done when faced with such a serious assertion that the document is fraudulent?
Yes. The closest reference that the UCP 600 has to fraud is Article 34, which says that banks are not liable for incorrect determinations. Essentially, the bank is not liable if it turns out that the quantity of goods, for example, that one document says were shipped, was in fact not shipped. If the bank has already honored that presentation, it is not liable to the applicant of the credit for that mistake. Accordingly, the certainty of payment is afforded by letters of credit is meant to ensure that banks do not have to do, in general, these investigations. The bank is presented with a series of documents which are supposed to represent a certain relationship and understanding between the parties. It evaluates those documents based on how they appear, and then it fulfills payment. For the bank to begin asking questions, going further, without a clear and obvious demonstration that there's something illegitimate happening with either the presentation or the seller, would threaten that security and certainty that is currently.
I understand that. And could you also please address me on any sort of public policy arguments there may be on a bank facilitating fraud?
of course, there is a public policy concern at play here, and there is a recognized exception for sort of clear and obvious fraud in letter of credit transactions. For this case, the bank only has a statement by the account holder that it didn't sign, and without doing anything else, it took that letter from a long-term client to decide, okay, there's fraud, we're going to take it. Now, for this tribunal, we have provided evidence that this is not a fraudulent signature, that the yacht has been, in fact, accepted and is being used by the buyer, and that therefore, while the bank should not have relied on that external influence that was not clear and obvious in making its initial determination, this tribunal can also find that the act of acceptance was not fraudulent.
Thank you.
Yes, thank you. Please correct if my understanding is right. The question is about the letter of the respondent of 10 March. You've mentioned that you consider this letter as not a notification of the reasons for non-acceptance of the presentation.
No, it does not include any reasons for rejection. In that letter, the bank says that it appears to be in order and that it's planning to honor payment.
Why? Because if we look at this letter, we can see that the bank told you that the act of acceptance was not signed by the authorized representative of the claimant. The signature on the act of acceptance appears not to belong to him. Is it not the reasoning?
No, you're correct. I apologize if I misunderstood. When the bank communicated to the seller, it did outline objections to the presentation. However, the bank had previously written to the buyer saying that it had completed a short review and that based on that review, it was planning to honor.
Understood. Okay. Thank you very much. And the second question is about the ship safety certificate. So the respondent's position is about the fact that the list of the documents for the presentation in the contract was not incorporated in the letter of credit because or it is not incorrect. Or the position of the claimant is that the list of the documents in the contract should be in priority over the list in the letter of credit.
Yes, our position is that a ship safety certificate was not required for payment.
And for this reason, you understand that the ship safety certificate was not required?
No.
Okay. Thank you.
Thank you. For the respondent, please, the floor is yours.
Okay, thank you very much, members of the tribunal. I represent Trust Me Bank. Trust Me Bank is a defendant in these hearings. My speech will consist of 3 parts. The first one is the bank didn't follow the buyer's instructions not to pay to the claimant. Second one, the act of acceptance and other documents were presented improperly. And the third part is that all claims of the MMX should be rejected. So let me go move on to the first part. We didn't follow the buyer's instructions not to pay. We contacted Mr. Avazov after analyzing the documents. According to the UCP 600, Article 16, quote, when an issuing bank determines that a presentation does not comply, it may, in its sole judgment, approach the applicant for a waiver of the discrepancies. This doesn't, however, extend the period mentioned in some Article 14b, which means that we made additional work to help the claimant get their money, but we failed after Mr. Avazov told us not to pay. The presentation wasn't improper, and let me move on to the second part. We didn't agree to pay in our first letter. We only said that the review, the analysis of the presented documents would only take place. The only, our only decision not to pay was mentioned in the letter sent to the claimant sent to the claimant on the 10th of March, and I would like to draw your attention to the case problem, page 31. So, as I already said, the presenting of the documents wasn't improper. I would like to point out that while determining whether we need to pay or not to pay, we followed the international standards of banking practice for the letters of credit issued by the ICC in 2013. This is the main instruction for the bank how to deal with the documents presented against the letter of credit. Also, the Article 14 of the UCP 600 quotes data in a document when read in context with the credit, the document itself and international standard banking practice need to be identical, but must not conflict with data in that document, any other stipulated documents or the credit. I'd like to draw your attention that the Act of Acceptance has the signature of Konstantin Zhivadlavsky. That's how we interpreted the signature, sorry, we might be mistaken. I'd like to draw your attention to page 28. But in other document presented, there was a shipbuilding contract on page please, on page 19, and the signatures are different, so the information comes into contradiction. From our other sources, because Mr. Ivazov has a credit card in our bank, we have a banking correspondence with this man. We know the signature of Ivan Aivazov, so we think that we believe that the signature of the Act of Acceptance is not his. It's common practice, it's common sense to believe that if one side of the Act of Acceptance signs and puts a stamp on it, the other side should do the same. But here we find that the signature was not the one belonging to Mr. Aivazov. Now let's move on to analyzing international standards of banking practice. Article 18 of the International Standards of Banking Practice documents that are not transferred, particularly the Act of Acceptance, must be made in compliance with terms of the claimant presented. Second, Article 3 of the ISBP 745 claims that states that if a document is in condition under the letter of credit, it must be signed. But the presented act contains the signature of an authorized person. Also, the claimant presented the documents that is not an act in the sense of VLC and contracts and conditions. Claimant's presenting is fulfilled when the documents presented are issued by the mentioned entity by any formal signs according to paragraph 20 of the ISBP 741. This formal sign is a signature of a person according to paragraph 20. According to the materials of the case, the respondent analyzed the signature of the act by comparing it with the existing signature of the sole authorized representative of Magnifesting Ltd, Mr. Aivazov. While the letter of credit, the respondent pays attention only to the documents and is not required to analyze the circumstances of signing the act. And also paragraph A27 of the ISBP involves the assessment of the evidence of the original signature. Therefore, we believe that the Act of Acceptance is not authenticated and is not properly presented. But there are other documents that are not properly presented. We would like to draw your attention to page 20 of the case program, where the documents provided for the payment are listed. First of all, a statement in the form of Annex 1, signed by an authorized representative of the beneficiary. The Annex 1 on page 23, and the one presented by the claimant slightly differ. They're not the same. A notarized copy of shipbuilding contract number 765 euro. There is no evidence that the claimant provided us with a notarized copy. There are no signs of notary on the shipbuilding contract presented in the case file. Invoice of the beneficiary, we don't have any problems with this document, either with certificate of quality and certificate of origin. The improper presentation of the act was already mentioned. The National Passenger Ship Safety Certificate